Hi guys, welcome back to my channel once again. This is Talk with Ola and my name is Mujala Olua. Today I want to answer a few questions that I've gotten on the channel so far. I'd like to say that please try and clarify your questions so that I might get to them faster and it might be easier for me to provide answers to them. So let me start with this person that asked, please explain marriage as a contract. Marriage as a contract simply means that marriage is an agreement between two people. It's that simple. What's a contract? A contract is an agreement between two people, and there are elements of a contract. I've done a video on that already. I'll leave a link to it in the description box. And some of the elements are agreements of the mind, that is, two minds must agree. The Latins call it consensus ad idem. And then there must be a proposition, like value exchange. That's consideration. It could be in kind, it could be in cash. That's money or non-monetary. And then it must be between two parties. That's privity of contracts. So and a few other elements. So that's essentially what we mean by marriage as a contract. And even to give it a contractual flavor, and under the act now, you have to sign a marriage certificate, both parties and their witnesses, which is another feature of a contract. There are sometimes witnesses to an agreement, just like in a land agreement there are witnesses, in corporate agreements, commercial agreements, there are witnesses as well. So it must be duly executed. So that's what marriage as a contract means. It means that it's an agreement between two people and that is regulated by law. Especially now we're talking about contractual, especially now when we refer to marriages under the act, that's the Matrimonial Causes Act. So that's what marriage as a contract means. I hope that answers your question. The next question goes thus: how can we make proper research for updated cases and laws with regards to the right books to use for one's case and how to use them to get results? Then the second question says that how can we locate cases most relevant to our case from the thousands of law reports without the use of e-libraries like Law Pavilion? And the third question from the same person says that when reading case laws from law reports, is it just the judgments or the entire write-up that is important to read up in order to get the information needed to support your case? So I think that the three questions can be summed up into two. So I'm just going to answer it this way. For the first and second questions about locating cases and books to use, without the use of e-libraries and all, I don't know if I'm the right person to answer this question because I'm as digital as they come. Yes, I've been addicted, not really addicted. I've been used to digital research even from my days at the university. Going to the library is not really my thing. It's not really it used to be my thing back in the days, but now it's no longer my thing. And honestly, I don't see any reason why anyone would have to go to the library or, go to some place to go and source for hard copy books. So maybe I'm not the right person to answer this question, but if I may attempt it, I would say that, digital research is the best. I mean, there's Law Pavilion, there's the internet filled with, cases, decided cases within jurisdiction, without jurisdiction, filled with papers that people have written on the subject matter or whatever topic you're looking for, and all of that. So why would you limit yourself to hard copy books and case law reports? I mean, when was the last time I read a law report? I'm not certain I've read one in the last 2 years. Yes, I've consulted some compilations of judgments in hard copy, but of course I also have them in soft copy. For instance, I write on labor law. Most of these cases, I get them. I review labor law decided cases by the National Industrial Court of Nigeria. Most of these cases are online. The National Industrial Court posts their own judgments online, full judgment, they post it online. And they even have an app. It was a friend, Ugochukwu, thank you so much, that told me about the app in, I think, 2020. And I've been using it since then. So, honestly, digital is my preference. So, maybe I don't have the right answer to your question, but I'll encourage you to just go digital. You could literally type in whatever you're looking for on the internet and it will bring you myriads of solutions, answers to whatever you're looking for. You get decided cases from different courts and different jurisdictions. You get opinions, from lawyers who have written or commented on the subject matter. and you get, papers written by professionals, academics, and experts on the subject matter. So I really think that digital is the way forward. I do my own research digitally. Even for law reports, for judgments and what have you, I do most of my research digitally. But if there's a library in your office or a library nearby where you can go to, please go there. If there's a librarian, they will help you with looking for the right cases. So the few times that I've gone to the library, I find that it's very useful if you can tell the librarian what you're looking for, instead of going to find it yourself, which I think is the challenge here. They will find it for you. They have indexes where they would look for the particular arrangement, of the case you're looking for or the book that you're looking for, and they will tell you what section of the library it is or where you should go to get it. So I think that that's something that you might like to explore. As for books, there are some books that are already popular among lawyers, regarding maybe property law and conveyancing, maybe criminal law and what have you. So I think that those books should be okay for you. Popular authors, authors that have become already so notorious that we even refer to them in court. So they could be useful for you if you need textbooks and what have you. But honestly, I think that's the answer that I can provide regarding that aspect. The second aspect is about reading judgments. You're asking if you're supposed to read the particular aspect that's relevant to the case or read the entire judgment. Honestly, I think it's instructive to read the entire judgment. I read the entire judgment whenever I'm reviewing a case, and whenever you actually need, decided cases to cite for one matter or the other, it's better for you to, read the entire judgment. It's better that way because, the aspects that you need to support your case is also contextually applicable. That is, the application is contextual. So for instance, if the court has said that you cannot, for instance, I'll use a label example now. If, for instance, the court has said that an employer is entitled to a 10-day notice before he or she can be fired, for instance now, and your own employee, your client, has been fired unduly from work, and you're looking for a decided case to back up, your brief that you're preparing for your client. It's important to read the entire case because, cases can be distinguishing of cases. I'm sure that they teach it in college or university. So cases are to be distinguished. If you were to read the entire judgment, for instance, you might find out that what the court means is that in certain types of employment, a 10-day notice is required before you can fire your employee. The court might mean that if your employee is in a kind of situation, or if they were employed in some kind of circumstance, so it might not just be a blank check for all types of employments and all types of employees. That's why you need to read your cases and the full judgment. And you need to read it because sometimes these judgments are contradictory. It's sad, but that's the truth. You find that the Court of Appeal held this, the Supreme Court held this, the trial court held this, in different cases on different matters. So there are different positions of law, per time. So it's important for you to read the entire judgment because even some of these courts cite the other. For instance, the Supreme Court, in reaching its contradictory decision, might have cited, a notorious case by a trial court or the Court of Appeal and say that, although the Court of Appeal held in so and so case that this is the position, they erred in law. This is the actual position now. So you wouldn't find that if you just go straight to the part that applies to you. And I know that if you're using law reports, there's like a list of the decisions, the ratio decidendi, outlined, I think, on the front cover for you to be able to go to the particular portion of judgment. But it's better if you read the entire judgment so that you understand the contextual application before you misapply the law. So I think that's the answer to your questions. These are the two questions that I'll take on this episode. There's a third question. Someone asked about IRAC and how to draft a brief. Please, I've been trying to look for a scenario, like a case study, for me to apply IRAC, just so you can understand. I haven't found. Please, if you watch this video and you're the one that asked that question, please send me a scenario at houseoflivingstones@gmail.com or leave it as a comment on one of the videos or where you asked the question initially, so that I can be able to apply IRAC and show you how it's done. Thank you so much for watching this video. Don't forget to subscribe. I will see you in my very next video. Toodles.